Michael Schuster here on behalf of the team of all types of divorce professionals at Divorce Specialist Group. I've spoken many times about the importance of hiring the right professionals for your divorce. That goes for any of the professionals that you might need during divorce. Some divorce coaches are far better than others. Not every insurance broker understands coverage for missed support payments. Divorce real estate specialists really do a lot more and understand a lot more of the intricate details than a general realtor. And not every lawyer knows the law as well as other lawyers. And I'm not a lawyer myself, so this isn't about self-promotion, but I've seen how this can be true in so many situations where I've worked with lawyers on behalf of mutual clients. While some lawyers do know the law very well and can answer your questions, they might not be proactive and think out of the box when it comes to preparing and negotiating your separation agreement. Here's what I mean. I recently filmed a video and wrote a blog post on spousal support, and I not only explained spousal support in great detail, but I answered some common questions such as, what if there is what's known as a material change in a spouse's income in the future after your divorce? Can the amount of spousal support be adjusted? So here's where things get really interesting with the law. When I was filming that video and writing that post, I was speaking with one of my favorite lawyers here at Divorce Specialist Group, and I learned something quite interesting. And that is that sometimes when you ask a lawyer a question, the answer is, it depends. Now you're probably thinking, well, it's either written in the act or it's not, which means it's either law or it isn't. Either a lawyer knows what he or she is doing or they don't. And that's not necessarily true. You see, I was talking about whether or not a spouse can revisit the topic of spousal support if one of the spouses has what's known as a material change in their income. So I started playing hypothetical with that lawyer. I said, what if a spouse earns $150,000 a year and when getting divorced is required to pay spousal support based on that income? But then that spouse the following year or 2 years later gets a new job and is suddenly earning $800,000 a year. Would that be considered a material change in the eyes of the court? So the other spouse could ask for an adjustment or an increase in the amount of spousal support that they receive. The lawyer's answer was, it depends. If the spouse earning $150,000, let's say was a lawyer who went to law school and later remained a lawyer but started specializing in some aspect of law, whereby they'd make a considerably larger amount of money every year, and started practicing law in the early stages of their marriage when the stay-at-home spouse could have been deemed to have played a part in that person being able to go to law school and build their law practice. So that might be considered a material change, it might not. But if the lawyer earning $150,000 leaves their law practice to start a different business or something totally unrelated, then the previous stay-at-home spouse had no part in their new pay increase. So basically, it does depend on the judge at the time. It would depend on the judge and how the particular judge on that day applies case law to his or her decision. So then I asked the big question that people always ask me. What if I get divorced and my ex wins the lottery or inherits millions? Is that considered a material change, and will that affect spousal support? Again, the answer was, it depends. This time, not so much about how the judge might rule, but on the separation agreement itself. And that's where having an outstanding lawyer comes into play. It's almost like the difference between a weak prenuptial agreement or an ironclad prenuptial agreement. Here's what I mean. When you have your settlement conferences or your mediation or your lawyers are drafting and negotiating a separation agreement, you can indicate what's important to you. And they have a number of clauses that they can insert into your separation agreement as long as you both agree. In my experience, and I'm only speaking about my experience in seeing and hearing about many separation agreements, I've personally not seen any couple or their lawyers insert a clause about lottery winning. The answer to whether or not you can get more spousal support, if and when that situation were to occur, the answer is, it depends on whether or not the topic was accounted for and covered in your separation agreement. So, in other words, if you suspect that your soon-to-be ex might come into a lot of money in the future, you might ask your lawyer or your mediator to put that in the agreement, and hopefully your soon-to-be ex will agree. Alternatively, if you expect to come into a lot of money in the future, or you're always investing in new startups and new businesses, or might inherit family money, or whatever the case may be, you could also ask for a clause in the agreement that excludes your ex from any future entitlement. It doesn't mean they're entitled to the money that the spouse who experiences the material change suddenly receives or earns, but whether or not they're entitled to an adjustment in spousal support. In fact, I know of one celebrity music producer who had this happen. I won't mention names, but when he and his first wife married, they both had nothing. So there was no prenup. But when they wanted a divorce, he was getting started as a successful music producer in Hollywood. In the agreement, she, being the wife, asked for a share of any future royalties that her husband might receive from the artist that he signed and produced during the time of their marriage. That was pretty clever of her or her lawyers, because that divorce was 20 years ago, and he's now one of the biggest music producers today. And his first wife is still getting her share of his royalties on those artists and those hits. So my best advice to you is, if you want to know more about this topic, we can connect you with a family lawyer here who is your best resource for matters like this. It's all about thinking out of the box and making sure everything, not just in the present but in the future, is accounted for and covered in your separation agreement so that you have the best separation agreement. If you have questions about this topic or anything else related to your divorce, just remember, Divorce Specialist Group does have all of the best professionals that you might need through your divorce, with the highest vetting process, the best track record of success, and they all have integrity and they genuinely care about what you're going through. You can email your questions. You can also request a free 30-minute consultation if you would like to do that. Everything, whether it's email, in person, on the phone, is strictly confidential, and there's never any pressure or obligation for anything at all. So just send an email to info@divorcespecialistgroup.com. Thank you for watching, and we do wish you well.